Well, good morning to my FB friends. My name is Peter Helder Bernard, and I'm your FB friend. Um, for those who don't know, I'm an attorney, and I practice law in New York, Florida, and throughout the United States, actually. And I'm a founding member of the firm of Bernard and Yem LLP, which is a very prestigious firm which handles various cases, corporate securities, immigration law, criminal law, as you name it. Um, Throughout the year 2015, I propose to host on my Facebook page a little segment which will be entitled "What You Should Know About the Law." During 1 or 2 minutes, I will be debating subjects having to do with the law and various things that I think that you should know about the law. We will be talking about immigration law, criminal law, foreclosure defense, and many other things. Um, I hope that this little segment can actually teach you something about what you should know about the law. If you know about the law, I think that you can better serve yourself and you can actually better serve the community where you live as well. So today, for starters, we'll be talking about grand jury proceedings. I know that many of you have heard about grand jury proceedings, especially in light of the Mike Brown case and the Eric Garner case in New York. We will be talking about grand jury proceedings this morning briefly, so you can have an idea as to what grand jury proceedings actually are, what's their purpose, and what they seek to accomplish. Now, let us first start by saying that grand jury proceedings are a tool of the prosecution. The prosecution, throughout grand jury proceedings, is trying to establish probable cause to determine whether or not a crime has in fact been committed. Um, Grand jury proceedings, many states have in fact provisions for a grand jury, but only half of them actually use them. Most courts often resolve to preliminary hearings prior to trial to determine whether or not there is enough evidence to amount to probable cause. Grand jury proceedings are also, we have to say, are not an adversarial process. In other words, you're not entitled to have a defense attorney during the grand jury proceedings. It's a tool of the prosecution, like we said, and the prosecutor works with the grand jury to bring about an indictment. Now, it is important to note also that even if the grand jury decides not to indict, the prosecutor still has the liberty to indict. However, she must prove to the judge that there's enough evidence to go forward with the case. And this is something that it's usually very easily done, which is in fact why it's quite surprising as to in the Eric Gardner case and the Mike Brown case that there was not sufficient evidence to prove that there was not sufficient evidence to establish probable cause. I'm not going to be debating these cases because I think that this would take too long. It would take more than 2 minutes. Grand jury are mostly composed generally of between 16 and 23 jurors. They have to, in order to come with an indictment, they have to have a supermajority. Supermajority is generally, in fact, between 2/3 and 3/4 of the jury has to vote in favor of the indictment, meaning to establish that there is probable cause. In New York State, for instance, no person who's in fact facing serious charges such as felony charges can be in fact charged unless there's a grand jury indictment. In other words, the case has to be presented to a grand jury. This is very different from the states where we've established who in fact prefer to have preliminary hearings instead of having grand jury proceedings because preliminary hearings are adversarial process. In fact, you are entitled to be represented at a preliminary hearing by an attorney who, in fact, it's almost like a mini trial, who sets about and brings forth your defense. Now, note that as far as grand jury proceedings are concerned, you need not, as long as there is inculpatory evidence, to prove probable cause, there is no need, no obligation on the part of the prosecutor to bring about exculpatory evidence to show in fact that you're not guilty, or that you've not committed this offense. Like we said before, grand jury proceedings are a tool of the prosecution, so you have to be aware of this fact, and the rights of the defendant at these proceedings are very, very limited. Of course, the defendant is entitled to appear and can in fact give testimony at the grand jury proceeding, which will tend to show that, whether or not he has in fact committed a crime. For today, this is where we'll stop. I hope that this little segment has been enlightening and has helped you understand the process. Of course, for those who want to ask more questions, we're very open to questions. You can actually call me at 305-650-9884, which is our Florida office number, and or you can call us at 718-413-2412, which is our New York office number. Again, my name is Peter Helder Bernard for the law offices of Bernard & Yem, LLP, and we look forward to assisting you with your legal matters. Thank you.